Now we get a chance to look at a remedies problem that is tremendously difficult and complicated. Here's a remedies problem that focuses our attention on where the law of contracts touches the law of real estate. So take a look at the call of the question, and you see it's about as vague as they ever get. What rights and remedies, if any, does Cal have? Discuss. Well, we know that Cal is going to have one or more theories of liability. They can arise out of torts or contracts or real property or any of the other subjects that can end in civil litigation. And we know that his prayers for relief generally can include damages, restitution, and equitable relief. An injunction in torts, specific performance in contracts. We go to the top of the problem, and from the very first couple of sentences, we can tell that we're going to be dealing with a contract dispute involving real property. Take a look at paragraph 1. We meet Sam and Bob, but notice we don't meet Cal. In paragraph 1, we find out all about the negotiations between Sam and Bob. We've got two parcels of land here, Blackacre and Whiteacre. The conversation between Bob and Sam first occurs on the telephone. Next, they meet and they work out their contract. And notice that the land sale contract that Sam's lawyer prepared isn't accurate. It doesn't mention Whiteacre, and it isn't specific with regard to the amount of acreage. Now, as we pause for a moment, looking back on our study of real property, and in particular real property land sales contracts, we know that property has to be described with particularity. But it doesn't have to be described perfectly. And this description appears to be incorrect, but the actual agreement between the parties appears to be quite correct. So we've got also in the first, at the end of the first paragraph, we get a little one-line second paragraph indicating that time is not of the essence. And that little one-line paragraph is going to prove decisive in the dispute between the parties. Now, look at what happens over the next 12 months. We've got A, B, and C, three different incidents that occur. In part A, we see that Bob sells his interest in the agreement to Cal for $10,000. All right, well, that's where Cal comes into the picture. He is an assignee from the purchaser. So Cal has got the right that Bob had to complete this purchase. So in A, we see that Bob has assigned to Cal, and that assignment is valid, and Sam is on notice about that assignment. In part B, we see that there's been a proposed freeway announced, and so the values of real estate in the area have tripled since the time that the original contract between Sam and Bob was formed. Well, let's just pause for a moment and consider that. Does this announcement affect the relationship between the parties? Answer: no. The contract had been formed earlier than that, and in fact, it had partly been performed. So certainly, the announcement of the freeway does not give either party any different rights than they had before. And then in part C, we find that all of the parties, Bob, Sam, and Cal, simultaneously learn that Blackacre's got 10 acres, Whiteacre only has 7 acres. So we pause and wonder, does this discovered fact alter the relationship between the parties at all? Again, the answer is no, because the originally contracting parties, Sam and Bob, didn't know exactly how many acres the parcels contained, but they did know which parcels they were talking about. And the fact that the land sales contract itself is facially ambiguous about precisely how much land is involved strongly implies that Part C in this A, B, and C set of issues is not going to impact the relationship between the parties. Now, we turn to the final substantive paragraph of this fact pattern, and we see that on the date that final performance was due, Cal only tenders $7,000. Well, that's not his obligation under the agreement. Cal's got to come up with $10,000. Cal wants an abatement on the purchase price, and he's not going to be entitled to get it. Furthermore, if he fails to make a perfect tender, the seller is going to get out of this deal, which is exactly what the seller wants. So we finally get, at the end of that last substantive paragraph, Sam rejects the imperfect tender and declares the deal off based on the breach by Cal. And we're going to see Sam's not going to get away with it that quickly because we have that one-line paragraph that indicates time is not of the essence. What does that mean? It means that a party that is not in full compliance under the contract has a reasonable time to cure. And then we get the call of the question again, what rights and remedies, if any, does Cal have? Discuss. Well, at this point, we know that Cal's theory of liability is going to be based on breach of contract. It's really a straight contracts theory. Then the remedies that will be sought include the specific contract remedy of reformation. Certainly, Cal is going to want the contract reformed to reflect the true intent of Sam and Bob. Then we're going to go through the various laundry lists of remedies, including specific performance of a land sales contract. So turn the page, take a look with me for a few minutes at the outline of issues that I've presented, and once again, I think you'll see just how invaluable it is to take your time, organize your thoughts, and present a well-crafted, well-organized answer to any question presented. Thinking clearly equals being organized. So let's take a look. We know that Cal's theory of liability is going to be contracts. So we have to examine the underlying agreement between Sam and Bob. Do we have any problems with regard to offer, acceptance, or consideration? No. The buyer has made a clear offer, the seller has clearly accepted, and the consideration is money exchanged for land. Now, we do have a problem with the writing. Sam's lawyer misdescribed the property. Does that error by the seller's lawyer invalidate the contract itself? Answer, no. The parties knew what their agreement was. The mere fact that the seller's lawyer has made some mistakes is not going to invalidate the deal because, although frustrating and a little embarrassing for the parties and especially for the lawyer, it doesn't prove that the parties didn't reach an agreement. They did, and parole evidence is going to be admissible to prove it. So, ultimately, we conclude that the earlier contract between Sam and Bob is valid. That requires us to turn next to consider the validity of Bob's assignment of his rights as buyer to Cal. Bob's interest certainly is assignable, and there's nothing in the deal between Bob and Sam that would suggest otherwise. Plus, we are told that Sam received notice, and we don't have any indication that Sam had any objections. And even if Sam did have an objection, there's nothing in the facts that suggest that there really is any merit to a potential objection. So we've got a valid agreement between Sam and Bob, and we have a valid assignment from Bob to Cal. So now we get to consider issues of performance, and this is where we consider the drastic increase in the value of the land that occurred after the contract was initially signed between Sam and Bob. Does that raise in property values affect these parties? Answer, no. But we also see that Cal, the man who is seeking to enforce this agreement, comes with not only with unclean hands, but comes being actively in breach of the agreement himself. Cal has only tendered $7,000 and $10,000 remain. Now, let's just pause for a moment and consider what's going on here with regard to Cal. Let's think about Cal for a moment, and let's be prepared to judge Cal. Cal is displaying the deadly sin of greed. Cal knows as well as everybody else that the property values have tripled, but he is trying to snake out of paying $3,000, and that act of real dishonesty, that attempt to breach this agreement and to provide an imperfect tender, is not going to allow him to have any remedies under this agreement until he is in compliance. So as we examine Cal, we have to judge what Cal's duties are under this agreement. Cal's got the same duties that Bob had. Bob has to make the second $10,000 payment to be entitled to the land. That's the deal that was assigned to Cal, and Cal has to meet that obligation in order to be entitled to anything. So Cal's rights based on breach of contract are potentially valuable. But Cal has to take himself out of breach in order to be entitled to remedies. So, now we consider remedies, and we see that our little laundry list that we thought of just by looking at the call wasn't quite enough. As we looked at the call, we realized that damages, restitution, and equity could well be at issue, but as we examined the facts, we saw that reformation is a big deal in this question also. And the first thing that Cal is going to want is to have the contract that he purchased reformed to reflect the true agreement between the earlier parties, and he'll succeed in having that done. The damages remedy here would be calculated based on the market price versus the contract price. So here we could assess damages with specificity, but when we consider the plaintiff's true desire, which would be an equitable order of specific performance, we see the damages are inadequate even where they can be calculated with precision as they can here, based on the fact that we're dealing with real property. All land is unique, and therefore equitable remedies become the preferred remedies of the parties. Now, before we consider the elements of specific performance, we could imagine that if this deal does fall apart, that Cal will be entitled to restitution of the $10,000 that Sam initially got from Bob. But that's not what this party really wants. What Cal wants is specific performance. So we see that damages are inadequate because land is unique. We've got ultimately a definite and certain contract once the document is reformed to reflect the true agreement of the original parties. Would it be feasible for the court to order performance? It appears the answer is yes, because the court has in personam jurisdiction over the parties and in rem jurisdiction over the real estate involved. Is mutuality present? Technically, yes, but that is the weakest element of the current specific performance checklist. Finally, defenses to equity. Well, here the seller's got a winning defense to equity and to any other theory that the plaintiff wants to bring, and that defense is that Cal himself is in material breach of the agreement, which he is. Cal's imperfect tender of $7,000 when $10,000 is due is a material breach of contract. Ultimately, in the long run, it would entitle Sam to abrogate the deal, to declare it rescinded. But since the original parties specifically agreed that time was not going to be of the essence, we can infer a reasonable time to cure. So the bottom line here is, should Cal choose to cough up the other $3,000 within a reasonable time, he'll be entitled to reformation, and he'll be entitled to specific performance. But if he fails to do so, if Cal fails to come up with this money in a reasonable period of time, Sam is going to get what he really wants, which is to rescind the agreement and to sell this land for its new higher value. And that concludes a discussion of a difficult, complicated remedies problem involving contracts and real property.